record button. And this will be available after the session in the member-only area of the ATA website. You're welcome to ask any questions throughout this, and this can be done in the chat or Q&A panels. If they are relevant and on topic to what is being discussed at that time, then we will pause to answer. Otherwise, your question will be left until the end. I will now pass you over to Aparna and Dan. Thank you.
Thanks, Alice. Thanks for the introduction, and welcome everyone to the talk IP Playbook, Guiding Your Toy Story. My name is Dan, and I'm a partner at Halfords IP. I specialize in the protection using patents and design registrations, and my colleague Aparna is a specialist in exploiting trademark protection and copyright and domain names. Halfords has been around since 1979. We have an office in the CBD, and we assist people to secure their intellectual property rights, but also to enforce them and to give opinions on when their rights may be infringed or in respect of the validity of their rights. So we'll go into a little bit of detail about, all those jargon words that I'm using so that you can better understand what I'm talking about. So the object of this presentation is just to give you like a basic understanding of the types of rights that are available to you so that you can protect aspects of your business and products. So if we think about what IP is, you should think about it as a bundle of legal rights that are available to you to protect different aspects of your ideas and creativity, and in a certain way, aspects of your reputation. They're essentially split into two broader categories. The first category is the unregistered rights. So these rights, you do not need to take any action to go and secure them. They automatically subsist on the creation of the IP. So examples of these are copyright, which automatically subsists and automatically creates in Australia in respect of artistic and literary works. And the other form of this unregistered rights are trade secrets, and these emerge from a body of law in relation to confidential information. So essentially, you can make a decision to keep your ideas secret, and then it will have some protection associated with it on the basis of the law of confidential information. The rights that we're going to speak about in more depth today are the registrable rights. So these rights you need to go and take action to secure in order to obtain them. The three rights that we're going to talk about are patents, which protect functional aspects of products or inventions, design registrations, which protect the visual appearance of products. So if there's significant value in the way that some of your products look, you might want to consider lodging a design registration. And the third type is a trademark registration, and these are used to protect distinctive signs, such as your logos, slogans, and your brand. So to help you just get a grip on, the nature of these rights and how they might apply to a product, we're just going to show you a simple product, and then we can have a look at how this product or how the inventors of this product sought to apply those IP rights to that product. As Alice said, if there's any questions that come to light, just feel free to pop them through.
Do you love golf but find it frustrating trying to bend over and push the tee into the ground? And frustrating trying to balance the ball on top of it? Tired of broken tees? Lost tees? Fed up with being sold products with this annoying method of sales presentation? How about I just talk like this? In 1889, William Bloxham and Arthur Douglas were given the first patent for a golf tee. It was a small flat disc with 3 prongs onto which a golfer placed the golf ball. Then in 1892, the Perfectum tee was designed by Englishman Percy Ellis. Now, the Perfectum tee was the first tee that was secured into the ground, and since then, not much has changed. Push the tee into the ground, balance the ball on the tee, play the shot, lose the tee, break the tee, find the tee, bend over and pick up the tee. Imagine a golf tee that you didn't have to bend over and push into the ground, that you didn't have to bend over and balance the golf ball on, that you virtually couldn't lose, that you virtually couldn't break, and that you didn't have to bend over and pick up. Introducing the Goose Tee. Simply drop the Goose Tee onto the tee box with the body of the tee to the opposite side of the golfer. Drop the ball on the ground, use the club face to roll the ball up the ramp, roll the ball into the tee, play your shot, then push the butt end of the grip into the diaphragm and lift the Goose Tee. The Goose Tee is incredibly durable. With a silicon shore rating of 50, they can withstand hot and cold climates and, of course, immense compression. Seen here during testing, more testing, and being run over by a car. Stored properly and protected from sharp objects, the Goose Tee might be the last tee you ever buy. For convenience during practice sessions, there is another feature that enables the Goose Tee to be secured into the ground during sessions with the driver, fairway, and hybrid clubs to stop it from tumbling away. If the tee is struck, it simply pivots around the anchor. It's easy to adjust and reset if necessary. The Goose Tee comes in 3 sizes, 45.
So yeah, hopefully, so that's a nice, simple product that we can use as an example. Hopefully you've all got a bit of a clear picture about what it is and what it does. So if we look at how the owners of this
teeing
invention
off from the same height every
sought to protect it, and let's just dive back and look at design registrations in the first instance, because these are the sort of simplest rights to apply for, but there is some complexity if you ever get into an infringement situation. So as I said before, design rights are lodged in respect of the visual appearance of the product. So if there's commercial value in the way that your product looks, then you want to look at seeking design protection. Often the industries where it's commonly used are fashion, furniture, tech. Apple is one of the biggest filers of design registrations in Australia because, as you would know, all their products have quite a distinctive look, and there's significant commercial value in that look. Everyone wants those phones that look in a particular way and the AirPods that look in that particular way. So if you look at the Goose Golf Tee registration, this is just an example of a design registration. All it is essentially is a lodgement of images in respect of the product from all different views to show what it looks like, because the scope of a design registration is essentially based on the images that you file. In order to be successful with obtaining a registration for a design, you need to have they won't just give you the design straight away. You need to have something that is new, so it can't have been seen anywhere else in the world, and it needs to be what's known as distinctive, and the legal test for that is whether it is substantially similar in overall impression to another design. If you meet those hurdles, then you'll be awarded a design that is enforceable. So this is an example. You can see here the images, the product name, Golf Tee. They last for 10 years. If you are successful in obtaining an enforceable design that's certified and has gone through examination, I'll just talk a little bit about that in the next slide, then you have the exclusive right to exploit that design in respect of that product or any design that is substantially similar in overall impression to the look of that product. So in the one sense, it is quite a limited form of protection because it is based on the drawings that you have filed. However, because you can get a bit of protection expanding beyond what's shown in the drawing because of the test for infringement is whether it's the same or substantially similar in overall impression. So an example of a case that went to the federal court, I think a couple of years ago, was in relation to these radio receivers in truck cabs. On the left, you can see the design registration that was filed. And on the right, you can see the product that was found to infringe the registration. And if you look closely at the differences between the product, there are significant differences. There's a speaker on the design registration that's not shown on the infringing product. The button arrangement is different. So in this case, it was found that the infringing product was substantially similar in overall impression to the registration, and they were found liable for infringement. Now, this is a very it's not a clear cut what may and may not be substantially similar in overall impression. It's quite a complex analysis, and there are certain things that come into consideration when you would be looking at something like this and whether there is infringement. One of the factors is whether you have given weight to particular features in a design registration using the statement of newness and distinctiveness, which is this statement here you can see in the center of the page. You might also give more weight to certain features by lodging the design registration with some aspects shown in dashed lines. Other factors that come into consideration are how crowded the market is. In a market where there is a lot of products, only a small change will be enough to show that you're not substantially similar. But in a market where they are sparsely populated, a small change may not be enough to say that you're not substantially similar. So it is quite a complex analysis, and I guess the thing that I'm trying to put across is that designs can be easy to file, and on the face of them seem quite simple. You just get the drawings and lodge them, but there are some subtleties that you would need to take into consideration when you are preparing the applications, to take into account these types of things that could happen in future with in an infringement situation. So the registration process is I'll just give you a brief summary of this. You would lodge the application. Within about 3 months, the application would be registered and published for all to see. It will not be enforceable though. So you could stop at that point and just leave it on the register if you wanted to keep costs to a minimum. But if you want your design to be enforceable, you would then need to go through an optional examination process, which you can do at any time during the 10-year term of the design. And at that point, the Patent Office will look to see what designs existed all the way back prior to the date that you first filed your application, and analyze your design on the basis of those 2 criteria I talked about before. Is it novel? Is it new? And is it distinctive or substantially similar to what's done previously? Another point to note is that designs are jurisdictional. So if you want to seek protection in other countries, you're going to have to file in those other countries. And if you can commence, the way that it's normally done is you commence with an Australian application, and then within 6 months, it's known as your completion deadline. You will need to select other countries of interest and lodge in those countries. If you miss that deadline, it can be fatal to security protection in other countries. But typically when you go through a process like this, you'll be working with a patent and trademark attorney firm, and they'll be on top of all these deadlines and will be, reporting to you when they're coming up and keeping you in the loop. So just a quick thing on searching. You can go onto, it's freely available on the Australian IP Office website. You can see, you can search the design register, have a look at, what your competitors have been filing. You can search by the applicant name, the owners of the registration. So if you wanted to go see and what, for example, Mattel had been filing recently, you just type in their name and it should show up. I last night, just out of interest, I just typed in toy for the product description, and these were the latest filings that have been lodged. So all of these are recent filings. So people are lodging for the protection of their new toys. And so yeah, in summary, with designs, they're inexpensive when compared to patents, but they can be quite limited because it is largely based on the image that you file. So if someone was to create a product that did the same thing but looked completely different, they would circumvent the design protection. So designs are limited in that way. You need to keep the design secret. If you're going to file for protection, very important to keep the design secret until after you have filed the application. Because when the design is examined, we go back to that examination process, and the patent office is looking for what other designs to show that your design might potentially not be new. They look for anything that existed prior to the date that you filed. So if you have published your design in a magazine prior to the date that you filed your design application, that publication could come up in examination, and then you'd be in a situation where you need to distinguish your design that you filed in that application from what's shown in that magazine article that you published, and it's an almost impossible task because it's going to be the same thing. So it can cripple your design rights.
Dan, sorry to interrupt, we've just got a quick question.
Yeah.
If you're creating a product and having it manufactured overseas, would you recommend that the design registration is in place prior to engaging the manufacturer?
Yes.
Asking this, given the timeframes involved in the application process, do we need to factor that in prior to manufacturing?
I think, yeah, I mean, I would suggest doing that. Yeah. If you've got the final form of the design, the issue with design registrations is that, you know, as I'm going to get into this next point. Well, I'll just answer the question first. Yeah, it's best to have it in place. I mean, that's a gold standard approach, to have it in place before you speak to anyone. Lodge the registration, then you've got a priority date, and then any foreign applications that you file subsequent to that will be linked back to that priority date. You know, if it so happens that you know, it's in a not ideal situation, if you've got a confidentiality agreement, you know, with the manufacturer and you trust them and it won't get out, then, you know, you could potentially rely on that. But the thing with those with confidentiality agreements is if they breach that agreement and the design gets published, that will still, you might have recourse against them for breach of confidential information, but in respect of your design rights, they might still be, you know, compromised because the patent office is not going to care about that. As long as if it's published before the date that you filed, that's all the patent office cares about.
Okay, thanks.
So with design registrations, and just in regards to timing, I know you said the person who asked the question was concerned about how long it takes to like lodge a design. It's quite a quick thing to lodge a design registration. It's not like a patent. You can just get the drawings and we can put them in, you know, within a couple of days. So it's not something that in that respect you should be concerned about. And it's important because it's so contingent on the way that so contingent on the images. It's very important that you lodge the application in respect of the commercial form. So not in respect of any prototypes that might be different in appearance to the commercial form. You need to wait until you've got that commercial form locked down and then lodge for that.
We just have a follow-up question as well. So if you're manufacturing in India or China, yet they are not part of your target geolocations for your product, would you recommend getting the design registration in that country as they are manufacturing the products still?
Yes, you can do that as well. If you wanted to stop manufacture or unauthorized manufacture in that country and sale in that country, then you would seek rights in that country. But if there was no market there, you could potentially, look, yeah, I'd say, yeah, as a gold standard, yes, you would probably just file in the country where you are manufacturing.
Yeah.
But in essence, you should also primarily look at where you're going to be selling the product. So if your biggest markets are the US, Australia, you lock down the rights in those countries, and then that stops anyone from, making or selling the product in those countries.
Yep. Thank you.
Okay, so now let's move on to patents. These are more complex than design registrations, and a lot more powerful. More difficult to obtain, a lot more complicated, a lot more expensive, but if you're able to obtain them, much more powerful than design registrations. So you can get them in respect of devices, products, novel processes for manufacturing, and chemical compositions. So just on the screen here, we've got the original lodgement for the Etch-a-Sketch. This is what's now known as the hoverboard. And then on the right was I think the original Play-Doh patent, which was a composition patent. So you can see here in respect of the Goose golf tee, they've lodged, this is an international application, but it's an example of just the front cover of a patent application and some drawings that are lodged. Obviously, the document is substantially longer than this. The typical length for like a simple mechanical thing will be 8 to 10 pages, but it can go up to hundreds of pages for like a biochemical invention or like a pharmaceutical. How it works, if you think about, if we contrast it to design protection, which is based largely on the images, the scope of protection provided by a patent is provided by a set of statements at the back of the document, which are called the claims. And because you're using words to define the invention, it can be very, very broad, and it's intended to cover things that do the same thing but might look different. So it's really honed in on the core features of functionality. So if you look at the claim that was originally drafted, I won't go into too much detail, but if you look at the claim that was originally drafted for this Goof golf tee, it uses very, very broad language, and that's the job of a patent attorney, to try and broaden out the language to cover all potential variations of the product or things that might do the same thing, but even though they look very different. So the attorney in this case, claimed a tee for a golf ball, so it's very general. The tee including a ball receiving formation, so anything that can receive a ball at a predetermined height from ground level, and a retrieval formation, which is adapted to receive and releasably hold or attach to a hand or end of a golf club. So that is all they've said. And they haven't defined, it's a ramp, it's got this aperture here with these tabs which lock into the end of the golf stick when you stick it in. They've just gone and defined it at its core elements, so that any product, the intention is that any product that now includes these broad features of a ball receiving formation in any shape or a retrieval formation in any shape would be captured by the patent. Okay, so this is where they started out trying to claim the world, get very broad protection, but the patent office doesn't just hand out the protection that you want. There's an analysis, there's an examination process, and again, they look for everything that existed prior to the date that you first filed your application and assess what you're claiming, mainly along two thresholds. The first threshold is novelty. Does what I'm claiming have a new feature? Any feature that is new and not seen, but anywhere in the world. So they search the patent offices of every country. It can be in any publication. They will search and try and find anything that can find that has these elements here that this person has tried to claim. The second threshold, main threshold that you'll need to meet with a patent is, in addition to having a new feature, that new feature cannot be something that is obvious to a person skilled in that technical area. So if we were designing, for example, let's just say we were making a new table, and we claimed that the table had Phillips head screws connecting the table And just hypothetically, no one in the world had, used Phillips head screws to make a table. And then there was that's not a good example, is it? No. Let's say Phillips head screw tables, were in existence, and then someone came along and tried to file for a table with flathead screws. You could argue that, look, the thing is different because it's got flathead screws, but it's an obvious thing to change because the screws essentially do the same thing, and just changing Phillips head screws to flathead screws is an obvious thing for a person skilled at making tables to do. So in this case, this is the report that was returned in respect of the Goof Golf Tee. They said that broad claim 1 was not novel. It also said it did not involve an inventive step. And just as an example, you can see some of the documents that they uncovered in respect of similar inventions. They found something, if you look at the one on the left, and if you consider the broad language of that claim that I read out, it's got here a ball receiving formation and the handle receiving formations. Those two broad elements are shown in this document. So the patent officer said, okay, well, you've claimed these two broad elements. Here they are in this document. Now explain to me why your product is different to this. So at that point, the claims are then massaged and narrowed to introduce more features. But as you introduce more features to the claim, the scope of your protection starts to shrink. So the patent application process is a lot longer than a design application process. It does have some similarities. You lodge an initial application. Typically, it's known as a provisional application. That'll give you 12 months of pending protection. At the expiration of that 12 months, you'll need to file what's known as a complete patent application. And then the application will just sit around for probably another year and a half until it is examined by the patent office. And they will do some searching and then assess your application on the basis of novelty and inventive step. Again, they search for anything that existed prior to the date that you filed. So it's very important, again, to keep what you have secret until after you've filed the application. Because if you have to distinguish from yourself, it's going to be an impossible task. For patents, it's a 1-year deadline from your first filing to extend protection to other countries. So, yeah, I mean, again, your attorney will just keep you in the loop as to when those deadlines are. Jurisdictional, need to seek protection in the countries of interest where you want protection. So if you want protection in India to stop, exploitation of the invention in any way, making or using the product, then you would lock down the rights in India. Spatial logical toy. Okay, so here we have some famous toy examples, just of patents that have been filed. It's interesting for me, to just go through all the, most famous toys. They're all underpinned by patent rights. So you've got the Rubik's Cube, original patent. This is the original Lego patent. This is one of the Super Soaker patents. Just some examples. And again, you can go onto the Australian Patent Register and search for patents that have been filed in Australia. If you might, for example, see a product that a competitor is making, you might want to do something similar. You might want to, have a look at, just have analyze to check whether they've got any rights. And then the place to do it is to go have a look on the register. You can see everything that your competitors file. You would definitely contact a patent attorney to properly do the search and then have a look at the document, determine the scope, and give you an opinion on, whether or not you might infringe. But this is, this is a common procedure that people do if they're concerned about infringement. So there's the link there to go and have a look at the Australian Patent Register, but you've got to, there's also, registers for every country. Another place you can do some searching, if it's of interest to you, is to go onto Google Patents. So you go to Google and type Google Patents, and Google Patents it's like a very user-friendly interface to search, and it will tie you into a number of patent databases. It may not be the most up-to-date, but for interest, you may want to do that.
Can I ask a quick question that's come from the attendees? So, are you considered as protected once the application has been submitted or only once it is granted? Because you're saying that, keep it secret as long as possible, but so you have to keep it secret till it's granted or
No, till it's filed.
till it's filed.
You
Okay.
just got to get it filed, and then you can go and exploit the market and try and sell the product. The reason why you want to keep it secret until it's filed is just because when the application is examined, they look for anything that existed prior to your lodgement date. Okay, you may have commercial reasons why you want to keep it secret longer than that, but from a patent's perspective, it's very important that you just keep it secret until the date that you file.
Yeah.
There is another thing I'll say about that. That establishes a date in the sand, your priority date, where you've lodged for protection. Okay. So someone else then subsequently seeking patent rights, as long as you precede them, I mean, you will have the rights to the invention. But however, you can't take action on the basis of a pending application. Okay. If your application is still pending and you've identified an infringer, you would need to, in reality, take measures to expedite examination of the application so that you expedite it into a granted state. And then once it is granted, you can then sue on the basis of a granted patent. Okay. Right. So that's with enforcement, you need a granted patent. But for like your general marketing and getting the information out there, you can commence with that, but just as long as after you have filed.
Okay, because you're stating that it takes 2 to 5 years to grant a patent.
If you let it go at its natural pace.
Yeah. Okay.
And most clients, if they go to a number of countries, they will just let it tick along at its natural pace until unless there is an issue, like a glaring issue of a potential infringer, because as soon as you start to compress the process, you start to compress the costs. So the costs come a lot quicker, and it can be quite an expensive process, particularly if you are going to a number of countries. So most clients like to just let it tick along and let the actions and work done and bills to sort of come at their natural speed, unless there's an imminent infringement threat.
Right. Thank you.
Yeah. So that is so yeah, just some quick tips. Yeah, I mean, with patents, the philosophy behind I won't have too much more time because there's only 20 minutes left. But the philosophy behind the patent system is that you are sharing your information, because when you're lodging a patent application, it is going to be published. So you're sharing the details of your invention in exchange for, if you're able to obtain a patent, you exchange for a 20-year monopoly to exploit that invention. Right, so that's the philosophy behind the system, so that when your patent expires, people can look at your patent and they can build upon it and then grow technology from there. So you might publication, if it's like a specific composition, you might not want to risk that. A different strategy might be to just rely on trade secret protection. The issue with that is if it ever does get out, then you can be compromised. So keep the invention secret before filing, and then get advice early. I mean, you can sometimes get away with lodgement of, like, say, for example, a design application, maybe by yourself, and not make too many mistakes, but to never file a patent application by yourself.
Thanks, Dan. So last but certainly not the least, let's discuss trademarks. Now, some of you may be thinking that if you are investing all that time and energy in protecting your patents and your designs, do you really need to bother with the trademarks? And the answer, my friends, is yes, you absolutely need to, because patents and designs have a shelf life. but trademarks are the only form of registered IP rights that are forever. So you can have them for eternity as long as you're renewing your trademark rights and registering them and using them. So trademarks are probably one of the most important assets for your business. So let's have a look at what are trademarks. Now, of course, when you think of trademarks, you're thinking of, brand identifiers, business identifiers like the name. But there are a lot of other elements that trademarks can protect, such as your logo. Now, even without knowing the names, the names aren't up there, you don't know what exactly the names are, but you know what the brand association there is, who is the commercial entity behind those logos. So logos can communicate a lot about who the commercial source is. Now, another form of trademark is color trademarks. Now, when I say a chocolate packet, a chocolate that's packaged in purple color, you're already thinking of Cadbury's. When I say, a mint-colored jewelry box, you're thinking of Tiffany's. So colors can be a very important identifier for your brand, for your business. And on the screen, you can see Rainbow Play Systems registration for their tri-colored canopy. Even from a distance, without exactly knowing where that outdoor play equipment comes from, you can tell, oh, that must be Rainbow Play Systems. That is their brand. So colors can be a very important element for your brand identity. Now, another kind of trademark are the shape marks. Now, Dan talked about the pattern that exists in the Rubik's Cube, but Rubik's Cube also is registered as a shape mark. So the same thing can be, you can have overlapping protection for it. And that's what you really want, to have the most robust protection for your product, for your business. We also have packaging trademark registrations in Australia, and that is quite important because unlike the US, where you have a separate registration system for trade dress, we don't have a trade dress protection. But if you are using consistent packaging, there are elements to your packaging that make your product stand out, then think about that as your product identifier, as your trademark, and I'd strongly recommend seeking protection for it. And something that's, coming up quite commonly these days are scent mark registrations. Crayola recently obtained a registration for their scent mark. When you open a box of Crayola crayons, it gets that very distinctive smell. So that is also now a trademark. In Australia, scent marks are still catching on. We only have 2 registered scent marks. It takes a lot of time and energy to actually register a scent mark. But if that is an important part of your product, for instance, the smell of Play-Doh, if that's what you're dealing in, if that is an important product identifier that consumers associate with your business, then do consider protecting it. And it is really important to try and protect all these different elements of your business's identity, your brand's identity, because when dupes come along, these are products that tend to cherry pick elements of your brand identity to make the product look very much like yours, but not quite yours. If you have separate registrations for all the different elements of your brand identity, you can take action against those dupes, because what the dupes are doing is they're trying to sail as close as possible to the wind by, copying an element enough to be similar, but not really infringing. So the more elements of your brand identity that you have registered, you've got protection for, the easier it becomes to take action against those dupes that are, cherry picking various elements. So here we've got a snapshot of the life cycle of a trademark, and it is quite self-explanatory, but I'll just quickly walk you through it. So of course, the life cycle starts with the development of your trademark. When you're adopting it, you're going through a selection process, typically with your marketing team, to identify what will you identify your brand as, what will be the key elements to your trademarks, to your branding. And once you've settled on what the trademark will be, what the brand name, the logo, the design will be, you have to do clearance searches to make sure that those elements that you want to identify with have not already been taken up by anybody and you won't be infringing anyone else's rights. Once you've done that clearance stage and you've got the green light that, yep, these trademarks, these identifiers look clear for you to use, you go through the registration process where you file for your trademark and you register it. The earliest you can get a trademark registered from filing is about 8 months. But if you encounter objections or oppositions, that timeline could be significantly drawn out to several years. So you want to get that registration process kicked off as soon as possible, as early as possible, and try and get that registration early if you can. But the most important part of the life cycle of a trademark comes in once you've got the registration. That's not where the story ends. It's actually the most meaty part of the life cycle, and that's enforcement. Now that you have managed to get yourself this monopoly, this exclusive right to use your name, to use the logo, to use the signs you've come up with, you really need to keep an eye on who else in the marketplace may be trying to do something similar. And if it comes too close to what you're doing in terms of the look and the feel and the message that it conveys, then you need to take action against them. For if you don't, that will dilute the monopoly that you have created. You will allow another party to coexist alongside you, accruing their own set of rights, and then it becomes too late to take action. So enforcement is critical to maintaining the integrity of your brand, to maintaining the monopoly that you have spent so much time, developing and registering. And then there's the global expansion bit. So if you've developed a product that's doing really well in the local market and you want to take it overseas, you've identified that there's a country where you think the product will sell well, then you have to pursue the registration overseas, because as you gathered from Dan's presentation, IP rights are territorial, so you are confined to the country where you've actually sought the registration. So now with that, for the next part of my presentation, I thought it would be good to give you a couple of really practical tips for each stage of the life cycle of a trademark, so that when you walk away from the presentation, you've really upped your trademark game, and you can avoid some really common traps that we see clients falling into. So starting with the selection stage, tip number 1 would be to adopt a distinctive trademark. Adopt a unique trademark. Now, there is an inherent tension between the marketing folks and between trademark folks, what the trademark law says. So marketing wants you to come up with a brand name or a sign that says something about the product. It communicates something about the quality or the nature or what the product is. But that flies straight into the face of what trademark law wants you to do, is that the mark shouldn't say anything about what the product is. It should be completely unique, completely arbitrary, because the moment you can derive a descriptive meaning, I can glean some, meaning about what the product is or what it does, your mark gets deemed to be descriptive. And the Trademarks Office, the Trademarks Law takes the view that if you are simply describing what you're dealing in, or you're exalting its characteristics, then those words should be opened for everybody to be able to use for their products that they're selling. If you're calling yourself Apple and you're selling apples, then you shouldn't be given that exclusive monopoly. Everybody else who's selling apples should be able to call them, their product what it is, apples. So as much as possible, you want to avoid adopting marks that are generic or descriptive. You want to err on the green side of this distinctiveness spectrum, where your mark is invented. It may suggest something about what the services are, what the product is, but doesn't really tell you exactly what the product is. So tip number 1, please adopt a distinctive trademark. Otherwise, you're going to spend a lot of time fighting with the Trademarks Office to get your trademark right. But even when you get that registration, after spending money and time, enforcing it will be very difficult, because other people could say, well, I'm just using it to describe my products. So with that, we'll move on to tip number 2. Please ensure that you actually own your trademark. Now, this seems to be obvious. Well, yeah, I'm going to own my trademark. But a lot of times, and I'm going to talk about 2 scenarios here that you can see on the screen. So scenario number 1, where you have engaged a designer or a third party, a marketing agency maybe, to come up with your trademark. Now, contractors actually own the rights in what they are creating for you, unless your engagement agreement with them, your contract with them, stipulates that any materials that they're creating for you are assigned over to you. If the contract doesn't stipulate so, please make sure that you are obtaining an IP assignment from them for what they have created for you. Otherwise, they are technically the owners, even though you paid them to create the brand and it is meant to be your brand. Now, the other scenario that we're seeing increasingly come up is people are using GPT and AI tools for creating their logos and brands. And, AI has made it really easy to do that. But the problem is the output that these GPT tools, these platforms are generating is the ownership of that, who owns the output is very unclear. It's very murky at this stage in law. So if you are relying on GPT tools, what I would recommend is add an element of human input to that output. So you've got the output from an AI-driven platform. Humanize that output by incorporating elements of your idea. So you can still use those tools, certainly for ideation, to come up with alternatives, but when you're actually settling on the brand or the logo you want to use, add your own touch to it, because that way you are contributing authorship and being able to claim the copyright, being able to claim that logo as your own. Now, I know some people will say that, well, the terms and conditions of these platforms clearly say that, they are all of the IP and the output is resting with me. But the problem there is these platforms don't actually own, at least not at this stage under law, clearly own that IP themselves. So they can't assign to you or give you ownership of something that they don't have. So they may say that in the terms and conditions that the user owns all of the intellectual property in the output that they are generating, but they can't guarantee you it. And it's more of a liability shifting mechanism for those platforms, because based on that, you may go out and start using your brand. But what if you find out later that it's infringing another person's registered trademark? With those terms and conditions, the platform has actually washed off liability over to you, saying, well, we don't own anything. We transferred that ownership over to you. So you are the one using it as it being your own. And so be very careful when using AI tools. And I would say humanize it, incorporate your input if you are using the tools for ideation. So another tip, please search before you use a file. And this is extremely important because recently a number of court decisions have said that in order for a trademark to have been adopted honestly, the courts need to see that you did your due diligence before you settled on that brand. If you start using your mark without doing searches and there's somebody else who you're infringing and they sue you, you will lose the defense to be able to say, well, I adopted it honestly and was using it concurrent to your use. So make sure you're doing your searches. And I've got an example here to really illustrate that point. You'll probably think this iOS logo that you're seeing belongs to Apple. And Apple did pour in a lot of money into their iOS operating system, started to use the mark, only to realize later that iOS is actually owned by Cisco Technology. And to this day, that remains the case. Apple, having invested so much, having already built the brand equity in their iOS trademark, had to approach Cisco to negotiate a licensing agreement. So iOS remains Cisco's trademark, and Apple has to pay a bunch of money to actually get it licensed and to be able to use that. You don't want to find yourself in that position, and you can avoid it by doing searches before you put any money, put in too much time or energy into your trademark. So search before you use a file. Now at Halfords, we offer a free trademark search facility. If you scan the QR code on your screens, you'll be taken to the website where you'll find the form that is on your screens. Even if you go to our website, halfords.com.au, you'll be able to access the free trademark search facility. So I would say strongly use it. It's a free facility, and you at least get that very early indication if your trademark is clearly a no-go, and then you can go back to the drawing board to come up with something new. Tip number 4. Now, this is the stage where you've adopted, come up with a trademark, developed the trademark, you've done your clearance searches, and it looks like your trademark is clear to use. You want to register it. A lot of clients come to us too late in the piece where they think they have registered it, but all they have done is registered their business name. Your business name is not the same thing as a trademark. A business name registration is merely an entity for you to start trading. It's what you use with the government to have that business presence. It does not give you any proprietary rights in that name. It does not carve you the exclusive monopoly that you can then use to stop others from using that brand. So business name registration, important to the business, yes. Needed to be able to trade, yes. But it is not intellectual property in the sense of a trademark, which gives you that exclusivity, that property right. So you have to still register your trademark in addition to the business name or company name registration that you may do. Now, there is something called the unregistered trademark rights. So these are called common law trademarks, where let's say you've got the trademark is clear for you to use or register. You decide not to spend the money for now to register it and just start using it. When you do that, you typically use the TM symbol. You would have seen it on products on next to trademarks. So the TM symbol means this trademark is being used as a trademark, but it isn't registered. Now, the problem with relying on unregistered rights is that if, let's say, somebody else comes along, Johnny come lately is using a very similar trademark, and you want to take action against them, when you go to court, you have to spend way more money to even establish that, yes, you do have a trademark right, because your right's not registered. You don't have any statutory piece of document telling you you own that exclusive monopoly. So you need to first demonstrate to courts that actually, look at this extensive use I have made of my mark over the last, 5, 10, 17 years. And I have accrued as a result of that use reputation in that brand, that it's become exclusively associated with me. Therefore, this person using it is infringing that unregistered trademark. But the cost of putting on that evidence is many times prohibitive for businesses to take action. It could cost you, upwards of $200,000 to bring a claim for what is called passing off, which is, infringement of an unregistered trademark right. You are far better off spending money at the start and getting yourself a registered trademark right and relying on that. Also, when you're demonstrating that reputation, your unregistered right is contingent on the amount of use you have made, the extent of use you have made. So your unregistered rights could be confined to the geographical area you're using the mark in. So if you're using it in Sydney or a suburb of Sydney, it's possible that the court will read down your unregistered right to just be within that area. Whereas if you obtained a trademark registration, you may have a business operating in Queensland, but your rights are registered Australia-wide, and you could take action against somebody in Tasmania to stop them from using a similar mark. So don't rely on unregistered rights. Go for registration. That'll give you the robustness of protection you need to be able to carry on your business. Then this is, again, a common mistake made by clients. So I would suggest, when you are looking to file, you've come up with a beautiful logo, you've come up with a brand name, strongly recommend going for registering the plain word mark. So going back to the example that we had looked at, the Goose Tea Golf, you would have seen the logo on their product in the video. They filed for this composite mark, what's called composite because it's got the design element, plus it's got the words to it. So the protection that you get in a trademark when you file for it, when you register it, is for the exact form in which you have filed it. So their protection gets limited to this composite logo form. Now, let's say somebody else comes along. They have used a completely different device, changed the words a little bit. So they're calling themselves Goozy or Goose without the, different spelling, but a very similar sound. If your registration is for the logo mark, for this composite mark with the device and the words, it will be very challenging to take action against these users because they have significantly altered, it's a completely different device, and they've also altered the wordings. So the Goose Tea Golf people would have been far better off registering the plain word mark. It gives you broadest protection in your branding, and it covers not just the plain words, the black lettering that you see, but it actually extends to all font stylizations and all colors. So if then the Goose crowd came along, you'd have a far better shot of taking action, because notwithstanding the device, the design element to their logo, the words are still the same or very similar to the sound and to the words in your mark, in your registration. So when filing, file for the plain word mark registration. If you have got a design element to it, like we can see this GTG device, obtain a separate registration for that device, and that gives you the broadest protection in your mark and in your word mark and your device. Now, tip number 7, and we have seen trademarks, applications, and registrations come undone even several years after the registration, because at the time of filing the trademark application, it was not filed in the name of the true owner. It was filed in the name of an entity that they wanted the entity to be trading, and they thought would be the entity that would be using the mark, or some such situation. So it's very important when you're filing the trademark, you identify who is the owner, and the application is filed in the name of that owner. And this typically comes up in situations where you've got a group of companies, and one company is the one that's created the mark, but then there's the other company in the business which is using the mark. So the owner is identified as the person or entity that authored the mark. So this is where, again, obtaining that IP assignment from your contractor is very important. So it's the person that authors the trademark plus is the first to use the mark. So if you were, let's say you're talking about a startup business, if you started off as a sole trader, and that you used the trademark when you were a sole trader, but then you incorporated an entity and you ended up filing the application in the name of that incorporated entity, your application could be deemed invalid because that incorporated entity wasn't actually the first to use it. It was the sole trader that was the first to use it. So be mindful of those things. Would strongly recommend consulting a trademark attorney or lawyer who can talk you through and figure out where the ownership of your trademark lies, and then files the application correctly in that name. Tip number 8, and that is you've got to spend time and money fighting fakes, because I know fakes are a big problem for the toy industry. And as much as, it's time consuming and costs money, it is very important to fight them. And there are strategies in which you can minimize that cost and put yourself in a better position to do that. So the first thing is monitoring the market and be strategic about it. So identify if you're concerned about online infringement, if the fakes are appearing online, identify the key platforms where you're seeing fakes for your business coming up, and then have some RSS feeds, or there are other platforms that you can use to keep an eye on those, social media platforms or other, e-commerce websites. So monitoring the market is key, and there are tools to do that. Another strategy could be making your product and packaging really hard to copy. So have a hologram or some design feature that is not that easy to replicate. So and if it's harder to replicate, it's an easier way for you to fight the fakes than actually having to take action against them. And part of that strategy, the next limb to that, is educate consumers about those distinctive features, about those unique features, so that they know, I can tell apart the fake from the original when I'm looking at this product, because it doesn't have that hologram on it. Or the original actually is built in this way. It has this red stripe or this particular feature. And looking at the fakes, you clearly know it's a fake because it doesn't have that. So spend the time, educating your consumers, making them aware. And also make them aware that if they are not paying attention and they end up buying a fake, then you can't really be held liable for it. You won't be able to help them out if something goes wrong with that product or toy. So educating consumers about the consequences of, about purchasing a fake, and how to actually identify a fake is a very important part of that fighting fakes strategy. And the last one that has worked well for several businesses is create an option, whether it's on your website or an easy way for for consumers to be able to report fakes if they identify it. So you're spending all that time educating consumers, but the consumers can also be your eyes and ears on ground in the market for you. So use them once you've educated them to get that feedback to be able to then catch the people who are doing, who are manufacturing the fakes. So I think creating an option to report fakes is a really good strategy to use for combating fakes. Now, that should be tip number 9, distribution agreements. Now, the Australian toy market is a net importer of toys. So a lot of times you're in distributionship agreements, in supplier agreements with toy manufacturers overseas. And when you do that, there are 3 things that are very important for you to be mindful of. One of them is make sure that the agreement gives you a clear license to use the IP. Sometimes it can be murky, and sometimes, disputes can follow from that. So when you're reading the distribution agreement, clearly read through what are your rights with respect to use of the IP, how can you use it, what's the manner of use, and ask those questions and settle that before you get into the agreement. Now, a lot of times, because the manufacturer is overseas, they may have registered their trademark overseas, but not turned their mind to getting protection in Australia. And it is possible that somebody else owns the trademark in Australia. So do the checks when getting into the agreement. If the mark is not registered, then get the manufacturer to register the mark or get their permission to do it yourself. But when you're doing that due diligence before getting into the agreement, you'll save yourself the heartache of being served with a cease and desist letter when somebody else has it registered and finds out that you're importing products with that name. And when that happens, you want to make sure that the liability for that infringement claim doesn't sit with you, but it sits with the manufacturer. So make sure that the agreement has warranties and indemnity clauses to cover you if you are served with a cease and desist letter and somebody is making claims of infringement against your business. And so the next tip is using the TM symbol. So there are 2 symbols with trademarks that you can use. I talked about unregistered and registered trademarks. I talked about that in the start. But what I wanted to emphasize with this tip is to make sure you can't use the R symbol until you get the registration in hand. But you can start using the TM symbol from the get-go when you have developed the mark, adopted it, it's clear to use, then you're good to use the TM symbol. And the TM symbol is a really good way to communicate to the world, even though you don't have the registration, but you can start communicating that this is your trademark, you are claiming rights on it, and you can put others on alert to not copy it because it's your brand, it's your trademark. So strongly recommend to start using the TM symbol when you're commercializing your product, your application is underway, even if you don't have the R symbol. Do not use the R symbol until you've got your registration in hand. It is actually an offense to use the R symbol for an unregistered trademark. And so this is the last tip. I mentioned this earlier, trademarks are territorial. So this tip more relates to when you're going global, thinking about the overseas markets. You can't enforce your Australian trademark registration overseas. You have to think about what are the key markets where you need to get, where you need to get the protection. So the things that you can think about and ask yourself is, well, where am I looking to commercialize my product? Where will your products be sold? Or where does the manufacturing or assembly take place? Because I think we touched upon this earlier. This is a good strategy to actually prevent counterfeiters from, especially countries like China, Brazil, and India, where counterfeit activity is actually pretty high. You want to bolster your rights. China in particular, I'll make a point, and I've made that point in the next bullet point as well, is a first to file country compared to Australia, which is a first to use country. So what that means is, in Australia, your rights in your trademarks commence from when you start using them. So you can have unregistered trademarks in Australia. Your duration of use gives you that right. But in China, even if you have been using your trademark for a really long time, that doesn't really count for much because there's no system of an unregistered trademark. Your rights only commence when you file to register the trademark. So Make sure for China being a first to file system, and there are other countries like Chile that are first to file countries, you get your protection, because even if you've been using the mark in that country for a while, that won't give you the rights to stand on to take action against an infringer. You will need to show a registration, and somebody else could beat you to the punch on the register and being a first to file system. So make sure you get your rights bolstered in those countries first. And then emerging markets where growth is expected. And this point in relation to prioritizing the markets really relates to, don't just think about the next 2 years, think about the next 2 to 5 years, because obtaining registration in some of the more emerging markets, more obscure countries, can be a long haul process. It may be several years before you actually get the registration in hand. In Thailand, for one of my clients, it's been 7 years and it's just under examination. So the examination process can take a long time. So make sure for the emerging markets, you are keeping a 2 to 5 year horizon rather than just thinking about where do I need to commercialize or plan to commercialize in the next 2 years. So those were the 10 tips that I had on trademarks. And how can Halfords help you? Well, as you gathered from the discussion, we can certainly help you patent your toy features and to keep competitors at bay that way. We can help you register your branding, your different elements of your brand identity, work with you to identify what brand identity elements really deserve the protection, where should you be putting your money. We can do clearance searches for you before you commence use, before you start to get it, even spend money towards the filing or the registration process, to make sure you're not conflicting with anybody else's rights. We can help you with dealing with counterfeiters. So we can come up with a strategy for you to fight fakes, fight dupes, and what would be the best way to get you the protection you need to put you in a good position to fight them. So stopping copycats, and then going global. Talk with us about your plans to go commercial overseas, and we can talk you through what the costs would be, what the risks are, what are the countries that you should really look to prioritize from a legal perspective, and then you'd be bringing in the commercial perspective. So we can help you talk about your commercialization plans overseas. And then if there are any further questions, we'd be happy to take that now.
Thanks, guys. So it is a little bit after 12, but obviously a lot of information packed into that hour. So we will have the recording in the back end, and we will also have a copy of the slideshow as well in the member only area. So moving on to questions, we do have another one for you both. If you register your mark in Australia and then go to market in Australia, will you cause issues for yourself if you want to register your mark in other countries later?
No. So patents and the designs are different in that respect. So for trademarks, there's no disclosure issues. Trademarks, you can, filing in your mark in Australia will actually give you a 6-month priority period where you can then file overseas and still be able to rely on the filing date of your Australian application. It does not impact your rights, overseas doesn't jeopardize those rights overseas. Yeah.
Thank you. Do we have any other questions just quickly before we finish up today's session? What are the cost ranges for each of these IP registrations, i.e. design, patent, trademark? Does it depend or?
Okay, so I'll start with, patents. You probably it's a long process. So your initial drafting of your patent specification will probably cost in the range of $6,000 to $8,000. It also depends on the complexity of what the invention is, and that's your initial filing. Then, depending on how many countries you go to, you're going to need to make lodgements in those countries. That step can be quite expensive, just as ballpark figures, for an English-speaking country, just to file in those countries using the specification that you drafted. It's probably around 5,000 or 6,000 Australian. Obviously, it does vary. It depends on, the attorneys that are used and that sort of thing. I'm just giving you ballpark figures. Non-English speaking countries have to pay translation costs to get the applications translated into language of that country. If it's a long specification, that can increase significantly the cost, but you could say ballpark, say around 8,000 for a non-English speaking country. So if you go to 10 countries, just for that filing step, it's going to be significant. And, you know, that's just to file. And then you've got to go through examination in every country, and you've got to deal with the patent offices in every country, all the objections raised in every country. So, you know, and that's, you know, I guess charged on a time basis, depending on the complexity of the inventions. So, I mean, difficult to say, but like if you looked at Australia only from beginning to end, I'd say you could probably get away with sort of 15 to 20,000. You know, but it is dependent on the situation. Designs are a lot cheaper. You know, of course, there's, you know, variation between the firm that you use as well, but, you know, you could probably get cost you like around 1,000 to 1,500 usually at a firm to file a design registration. And then there's not much, you know, issues with the examination or anything like that. So it should just go straight through to registration. If you wanted to get it certified and enforced, then there's going to be additional costs associated with that. But like, let's just say, you know, maximum, no, I guess not maximum. I'll just say, look, between 5 and 8, maybe around 5 to go through the whole process. If you did the certification process at the end that no one else sort of does, that not a lot of people do, without there being an infringer.
Quite big.
Yeah, that's a summary. Yeah, it's definitely on a case by case basis. I tried to give you like just a bit of a snapshot. But,
yeah.
And trademarks are also on the cheaper side compared to patents for sure. So trademarks are dependent on the number of goods and services that you're really seeking the monopoly in. So the number of classes, because all goods and services are classified in 45 classes. So the cost of one class, the official fee payable is only $400, and then there is an attorney fee that ranges from firm to firm. But typically, from filing to registration, if you've got no issues with during the examination or application process, it could cost you between, I would say, $1,200 to $2,400 is the typical range. Yeah.
It all really depends on whether you hit issues.
Yeah.
Yeah.
Yeah, but like, I mean, generally when you engage an attorney, you like lay out the plan. You know, most firms, including our firm, are like, we're happy to just chat to you, like, you know, for free of charge, discuss what you've got, have a look at the types of protection that may be suitable, and then we would give you sort of a summary of, you know, the expected costs and what you can expect, depending on your circumstances. And the other thing, just to say, just as a precautionary note, is that, you know, all the information we've given you is very general, and, you know, there are a lot of subtleties, as I'm sure you can understand. So, you know, if you have a particular situation, I mean, you'll need to, you know, speak to us for more specific advice. Yeah.
Yeah. Are there any other questions while you have time with Dan and Aparna? Also, if you're okay, Dan and Aparna, I'll share your email addresses. If anyone has any queries, they can obviously come to us, and we'll share the details so you can get in touch with the team.
Yeah, that's fine.
I'm very happy with that. Yeah.
Anytime.
Yeah. Okay, thank you. We might leave it at that. Thank you, Dan and Aparna, for your presentation today. As I said, it was a lot of information, but definitely interesting information that I learned as well, and I'm guessing that everyone in this webinar also learnt. So thank you. Thank you for those who did attend, and yeah, we'll have everything up in the back end shortly.
Great.
Thanks very much.
everyone.
Thank you.
Thanks, guys.